should be happening back in Ohio. But let's take something more simple, and that is we
Okay.
have a family that lives here in the state of Florida.
Mm-hmm.
They're going to seek a divorce here in the state of Florida. That's going to happen in the county, I suppose, where they live.
Generally speaking, yes.
Okay. And so then tell me what's going on with young kids these days. You know, historically, we've always talked in terms of child custody. They don't even use that term anymore.
That's correct.
So what are they talking about?
What they're talking about is shared parenting and shared parental responsibility. And the legislature has rewritten the statute over the past several years. And instead of having custody, which was not a word, a technical word, from many years ago, and from primary parental responsibility and shared parental responsibility, we've cut out primary parental responsibility and secondary parental responsibility to get rid of the idea of having winners and losers. Instead, in order to focus on the children, the courts are now authorized to implement a parenting plan and a plan for shared parenting. And the parenting plan includes what's called a time-sharing plan, whereby the parents get together, or the court imposes if the parents can't agree on it, what the time-sharing schedule will be for a child or children and their adult parents who are no longer living together.
Well, historically, the court would put the children with the mother. This is trying to equalize things out. And so when you talk about the shared parenting, are you, in a sense, literally talking about an even number of days that the children are with dad and with mom?
Well, not necessarily, because it depends on each party's job responsibilities, their job schedule. The schedule for a 4-year-old child is going to be different than the schedule for a 16-year-old child who has a driver's license. So each case is unique, each case is different, and in fact, the law, the new statute, and the glitch law, as I call it, to get rid of any kind of a presumption for one schedule or another, the glitch law for the most recent change in the time-sharing plans creates, it says in the statute that there shall be no presumption of any schedule in favor of anyone.
And so how, for going to school purposes, are they using mom's where mom lives, or are they using where dad lives?
Where the parties decide, or the school district in which the kids live at the time that the divorce is finalized. And the only real designation that is in a parenting plan now is designating a physical spot for school designation purposes. So if mom lives in that area, for example, mother will be the designated residential parent for that purpose only. Or it could be dad too.
And so who then, for medical purposes, who's deciding whether the child needs braces or doesn't need braces? If who's deciding when the child goes to see the doctor? If the child needed emergency stitches, are either one of them authorized to get those done?
Well, you're distinguishing between an emergency and the day-to-day, week-to-week, month-to-month medical care and dental care for a child. If it's an emergency, whoever that child is with, go to the E-room. That's a presumption. Notify the other parent as soon as it's reasonably possible to do so. But for things like braces, orthodontia, regular medical checkups, both parents should be aware of these things, and both parents should coordinate their schedules so that they're both aware and both, if possible, able to connect with that medical professional at the time.
Hey, folks.
That's one of the things about shared parenting. It's called shared parenting.
Folks, my name is Tom Olson. The name of the show is 11 Lawyers Radio Show every Sunday at noon.